In 2017, Alex May acquired land in Spokane, Washington. Through a title search, he discovered a provision indicating only whites could live on that land unless they're to serve or work for a white owner or tenant. The provision was added in 1953, despite the Supreme Court declaring racially discriminatory covenants unenforceable in 1948. In 2013, a bullet was added indicating that the racially discriminatory covenants were deleted. The Mays are not satisfied with this, and they want the racial verbiage redacted completely from their property records. They now escalate this issue to the Court of Appeals.
My name is Judge Rebecca Pennell. Also joining me on panel are Judges Robert Lawrenceberry and Judge George Fearing. The first case on today's docket is Alex May versus County of Spokane and Vicki Dalton. So, Mr. Fry, you're a Rule 9 intern. Welcome to the Court of Appeals. We're pleased to have you here, and let us know how much time you would like for rebuttal.
Thank you, Your Honor. I would like to reserve 5 minutes for rebuttal.
Thank you. You may proceed.
Thank you. May it please the court. As stated, my name is Kyle Fry. I am a Rule 9 intern and a third-year law student at Gonzaga University. My supervising attorney is Brian Pham, who is also present with me here today. We are representing Alex May, the appellant in this matter. And we respectfully ask this court to reverse the Superior Court's decision, which denied our request to eliminate the racially restrictive covenant at issue from the public record. We ask that you do this for 2 reasons.
Mr.
First,
Fry?
Yes, Your Honor.
Does the county auditor still have in her possession the original non-electronic copy of the 1953 Declaration of Protective Covenants?
That is our understanding, Your Honor, yes.
And does she have in her possession the original non-electronic copies of the intervening deeds on Mr. May's property and the deed to Mr. May?
That is also our understanding, Your Honor, yes.
Did Mr. May receive a title report when he purchased the property?
Yes, Your Honor.
Did the title report reference the 1953 covenants?
Yes, Your Honor.
Did the title report indicate that the racial restrictive covenant was no longer encumbering the property?
Yes, Your Honor, that it was no longer encumbering the property, but it still was in the public record.
Is it your claim that the racial restrictive covenant is still on Mr. May's title?
It is our claim that the racially restrictive covenant is still on his chain of title and still accessible in the public record through a title request.
Did the deed to from Gregory to the Lakes, the 2013 deed, specifically strike the racial covenant from the title?
It specifically struck the racially restrictive covenant from the title. However, the racially restrictive covenant was still found during this title search.
What is a person's title? How do we know? How do I go to find out what somebody's title is?
In order to find out what somebody's title is, you would do a title search through a title search company. They would show you not only the deed, but also any attachments prior to the deed, including these racially restrictive covenants.
So, and didn't this title report show that there was no racial restrictive covenant on the property?
The title report showed that the title or that the racially restrictive covenant had been voided and had been stricken. However, there is still in the public records access to this racially restrictive covenant.
Is the 1953 covenant and the intervening deeds also in electronic form with the county auditor?
My understanding is that the answer to that question is yes. However, I would direct that question towards the county auditor.
What does Mr. May want the county auditor to do?
Mr. May would like the county auditor to strike and eliminate all indications that this void provision was attached to his property. He doesn't want it to be findable in the way that he found it. He doesn't want the next purchaser to be able to find it in that same manner.
So when you say strike, what do you want the auditor to physically do?
When I say strike, I mean to remove and delete. If that is in a hard copy, then a black marker or a whiteout pen would be acceptable. If it's an electronic copy, then the electronic deletion of that record.
And how would how would you effectuate an electronic deletion?
I would put the burden of effectuating a court order to delete that public record on the county auditor. I would rely
Well,
on
do
her
we know if
expertise.
it's even possible?
I would say that it's definitely possible to alter a public record. It's certainly possible to delete things electronically as it is physically.
Mr. Fry, a
Yes,
concern
ma'am.
I has, if we were to rule in your favor, don't we risk erasing some of our history? And if we erase our history of racism, do we risk that there will be deniers that this racist past ever happened? And is it really in the public's interest to start erasing vestiges of racism?
That's an excellent question, Your Honor. Thank you for asking. We are not trying to effectuate a removal of the history of these types of covenants. And actually, if the county or the auditor wanted to create some sort of a historic monument or have some sort of historic record referencing the existence and the meaning behind these sorts of covenants, we'd be all for that. We just don't want, our client does not want to have this racially restrictive covenant attached to his private property in the public record anymore.
Sure, no one does. If you bought a plantation down south, you'd really hate to know that slaves were owned there and tortured there perhaps. But it's important to know that that property was a property that perpetuated slavery. Isn't it important to know that certain pieces of property had a history of racism?
Absolutely, Your Honor. And again, we do not seek the destruction of this from the historical record in its entirety. We simply seek for it to be removed from this person's home and from the public record attached to that. It's an important piece of history for sure, but this is not the way to record that. Most people don't know that these are on their home until they do something like a title search. So certainly discovering the public record through that means is a little bit ridiculous, I think.
But would it upset a subsequent buyer? Let's say a buyer is really concerned. I want to have a house that never had a racially restrictive covenant on it. I want to do a title search, and that's important to me as a buyer. It's going to make the decision between buying or not buying a piece of property. If we hide it, we're hiding that information from the buyer, aren't we?
That's a good point, Your Honor. However, I would point to the several articles in the news that have described the entirety of the Comstock area that is subject to these types of covenants and the public attention that this case has brought to those. It's not our intention to hide this from the public eye, and I believe that an individual purchasing a home in that area who is versed in these types of covenants or trying to avoid them would be able to have access to that through both the media and, if the county wanted to preserve this in a historic record, through the historic record.
If I could jump in with a question, if I may.
Absolutely.
Okay. Very good questions for both my panel members, but I do have just one. It has to do with statutory intent. The statute we're talking about is RCW 4960.227. And in that statute, it specifically states that the lawsuit shall be brought in the name of the property, an in rem action. So one might assume that, for example, your title should have been captioned in re parcel number, 3219847, Spokane County. There's nothing in the statute, though, that mentions that you shall also bring an action against the county auditor. And in order to get the relief you're requesting, you would need to bring it against the county, or at least the county auditor. If you, my point or my question is, if indeed the statutory intent was to physically strike the language, you think that as the statute was saying, how the title has to be captioned, that it might also say that it also must be brought against the county auditor.
That's an interesting point, Your Honor, and I don't mean to say that the legislature had some oversight in that area, but it's quite possible. They did, however, describe that we were supposed to put the title as the description of the property, and at the Superior Court level, that's precisely what we did.
Mr. Fry, RCW 4960.227.1b reads, if the court finds that any provisions of the written instrument are void, it shall enter an order striking the void provisions from the public records and eliminating the void provisions from the title or lease of the property described in the complaint. Does this language in the statute suggest that a court order alone is sufficient to strike the racial covenant from the record?
Yes, Your Honor, I believe it does. A court order pursuant to this statute would effectuate that claim, and I would point to the county auditor's duties to be bound by legislative, by I'm sorry.
But does this suggest that a court order is what strikes the language and that the auditor does not need to do anything further?
It is our position that as the keeper of records, the county auditor would be a necessary party to effectuating this order. And so that is why we have attached her to this claim.
Okay, then in turn 496227-2C, which references the alternate step of filing a modification document, reads, the modification document must state in part, the referenced original written instrument contains a discriminatory provision that is void and unenforceable. This document strikes from the referenced original instrument all provisions that are void and unenforceable under law. Does this section of the statute suggest that the striking of the covenant only means filing a new document, not obliterating all mention of the covenants from the record?
No, Your Honor, this action was brought under RCW 496227 subsection 1, which is outlining the declaratory judgment action that we've pursued. The section that you've just referenced refers to an alternative, that is to file this remedy as a provision after the fact.
But these alternatives suggest that in order to strike something, another document filed with the record is sufficient. You don't have to go back to the original records and do anything. Do you agree with that?
I do not. I feel as though if the judiciary had, or I'm sorry, if the legislature had intended for that to be the only option available, and if that for that to be the main intention of this statute, then they wouldn't have provided subsections 1A and 1B as the type of action that we've pursued.
A rebuttal, so I'll stop. I have other questions, but I'll stop at this time.
Thank you.
Thank you, Your Honor.
Mr. Catt?
Your Honor, the records that we're talking about here, 4960-224 makes a distinction in the language between the title record and the chain of title. In sub 2, it makes it an unfair practice to insert into any written instrument. In other words, the contract for sale, the deed, a discriminatory language. And then it also, in the second part of that sentence, it makes it a unfair practice to attempt to honor one that's in the chain of title. So there's a distinction here. It's the county's position that the removal of the language is on the title itself, and that the court's action and the order that the court entered is sufficient in order to strike that language and remove it.
Mr. Catt, if you know, does the county auditor still have in her possession the original non-electronic copy of the 1953 covenants?
I wasn't asked that before today, but my understanding is of a practice is that all of those hard copies are transferred to archives and the county keeps electronic copies. The county had a vault where all the hard copies were, and those were all scanned in and transferred. So I do not believe that the county has those records, the hard copy records, the original one. And also these records are maintained by the title insurance companies. So the chain of title records they're distributed. My understanding is that the title companies would come in and look for updates. They would use their own database that they've acquired over the years in order to do the earlier search.
If you know, can the county auditor make changes to electronic copies such that what was originally in the document is no longer part of the public record?
The county auditor does not do that. The county auditor does not make any.
Have the physical ability to do that?
Not, I mean, anybody, I suppose, has the ability to do that if they searched through the record, located it, and then did a redaction on it. But that wouldn't get it out of the document or out of the chain of title or out of Mr. May's deed if it were in there, but it's not in there. If it's in there, it was inserted back or referenced back by the Lakes, because the prior owner to that clearly removed it. It deleted that section.
The county auditor is concerned about liability by altering documents that are recorded. Does RCW 4060.227, which directs that the covenants be stricken, protect the county auditor from any liability, because the statute 4960.227 is more specific than the general statute that prohibits alteration?
Your Honor, there's no authority other than if the court were to reverse this or issue an order ordering the state audit or the county auditor to redact language. That would mean that the county auditor would have to go in, search all the records, and redact something that was in there, and that changes the chain of title to do that. The person who has that authority on the retention schedules and whether or not that document is an archival for permanent retention is the state archives, and that's who the Secretary of State's office, I believe.
But if there's a court order pursuant to the statute directing the county auditor to completely obliterate from the public records any reference to the racial restrictive covenant, does that protect the county auditor from liability under the statutes referenced by her?
I would think that, and I mean no disrespect on this, but I would think that if an order were issued to that extent, it would go up, because that would be in direct violation of the county auditor's other duties under the other statutes. And it would be,
it would go up to the Supreme Court.
Yes.
But what if the Supreme Court affirmed the ruling? Wouldn't that protect the auditor from liability?
Well, we would have the state involved in it at that level. So I think effectively it would vet out whether or not there were any constitutional violations or anything else at that point in time.
I do have a couple questions. Mr. Catt, I was in private practice for about 21 years, did a lot of real estate and construction law. I have a lot of experience looking at the public record, because sometimes chain of title is important in those issues. And it's been my experience that a lot of nutty things sometimes get filed in the auditor's office, such as people making certain types of claims, slander against title, things of that nature. Are you aware of any statute that actually directs or authorizes a county auditor to physically strike something, language, in a recorded document?
No, I am not, Your Honor. There is a statute that relieves the county auditor from liability if somebody files something that's improper, but the county auditor's duty is to accept filings. If it's something that can be filed, that's the county auditor's duty. She must accept it. She must file it. The statutes governing the county auditor are very clear that she cannot make any changes to it. You can't delete anything.
It's a ministerial act.
In a timely fashion.
Yeah.
I'm sorry, Your Honor.
It's a ministerial act. If something's presented to her for recording, and if it meets the requirements as far as the formatting requirements, It's a ministerial act to record it.
Yes, it is.
Mr. Catt, what is the difference between the two subsections under 4960.227? Why have two different subsections if they don't do different things?
Originally, these covenants governing not just Mr. May's property, but they were covenants governing a plat. Okay, so multiple properties. Section 1, for all practical purposes, has been there for many years. And what that allowed the property owners to do was to go through and remove those covenants completely, or to amend the covenants completely. And Mr. May still has that option. He can go in, he can get the signatures of the other property owners that are subject to that, and they could do away with all those covenants. And I addressed this with Mr. Eichstad, who was the original attorney on this. Under subsection 2, I mean, we live in a different society today. So this was an easier way for someone to go in and make that change, delete that language from their title, from their deed. Didn't remove it from the chain of title, but in this particular case, Mr. May's property isn't even subject to that particular provision in that earlier 1953 covenant set. But if the court were to order us to go in and change that original document, we would be impacting all of the properties that were subject to it. And none of them have had notice. I pointed this out to Mr. Eichstad. I also suggested to him that you could remove it the same way or similar to, he could take that original document if he didn't like it. He could delete the language and he could refile it. And that's the way that documents and recorded documents are updated in the chain of title. You get something that's recorded over the earlier one. So if he wanted something that was stopping it on that particular property, I don't see any reason why he couldn't do that. He could file it, have the court order attached to it. The chain of, when there was a title search, it would look at it. It would clearly point out that that was the covenants governing that property. And it would stop there. So there's several alternatives to this. When we're talking about trying to order the auditor to do something that's not, she neither has the authority to do it nor the duty to do it. That's the concern that we have. It's no contention at all on our part that language is appropriate or the language should stay on there.
Mr. Catt, I want to follow up with Judge Pinnell's question. Is the fact that Section 2 allows for the filing of a document to declare the racial covenant void suggest that when the plaintiff brings a lawsuit under Section 1 of the statute, that something beyond just filing a court order or a document should be done to strike the covenant from the public record?
I don't believe so, Your Honor. I do not believe that I think this is just an easier way to do it. You could, as I indicated, you could remove all of those covenants, the whole covenant concept under one.
What does subsection 1 add to the law beyond what's in subsection 2?
Well, it would allow the association, the homeowners association, to come in on the board themselves and act on that language and impact all the properties underneath of that association. It's broader than 2.
Mr. Catt?
But both of them require the property to be subject to those provisions. And Mr. May's property is not, because that was deleted multiple times.
Mr. Catt? In the record, do we know how many properties are affected by these covenants? How many parcels? Are we talking 5, 10, or 20?
that development was done in phases with multiple plats. I don't recall exactly how many properties there were. I think that there was under 20, if I recall correctly.
Because it seems to me that if we were to grant the relief that Mr. May is requesting, that in order to effectuate the relief, that it has to apply to not just each of those properties, but the chain of title each time it passed from one property, one owner to another. And that may be, hundreds of documents that need to be physically altered, not just in paper form, but in electronic form.
That's correct, Your Honor. Yes. That, if it were as simple as, our view under the statute is it allows them to make the change so that that property is not there. When you look at the title or the deed on that property, the language is not there. It's not subject to it. It's removed. It doesn't have to go forward. Chain of title is a different issue. That goes back to land grants, I assume.
Mr. Catt, you have about 30 seconds remaining, or do you want to submit your argument?
I will submit it. I thank you for obviously reading through this and making considerations. Request that you deny the appeal. Thank you.
Mr. Fry, I think you have about almost 4 minutes of rebuttal.
Thank you, Your Honor.
Mr. Fry,
yes, Your
is
Honor.
the restrictive covenant more in the nature of a statue to a Confederate general in the public square, or more in the nature of a history book that records the terrible discrimination that's been imposed on Blacks in this country?
It is much more akin to the Confederate statue in a public square if part of that public square were privately owned.
I want to read to you an article from the Seattle Times, January 7, 2019, titled, "The deed to your Seattle area home may contain racist language. Here's how to fix it." Towards the end of the article, it reads, "The covenants cannot ever be completely removed because they are part of the property record. The legislation," and then quotes, "simply gives the property owner the power and the right to add essentially a statement that declares that this is obnoxious and null and void," close quotes, said James Gregory, director of the University of Washington's Seattle Civil Rights and Labor History Project. Then quotes again, "I'm not sure we want to get rid of them," he said. "They're part of history. They should be acknowledged, not hidden." What, if any, response do you have to Mr. Gregory's comment, which I believe is joined by Curtis Robinson, the NAACP leader in Spokane?
Your Honor, he has since withdrawn his position on that, although I am aware that he was originally on that side.
He being Mr. Robinson or Mr. Gregory?
The local NAACP representative, yep. To that, I mean, no disrespect to that, I'm sure, esteemed professor, but the legislature directly expressed their intent by passing the statutes we've been discussing in their 50th session by stating that the continued existence of these covenants and restrictions is repugnant to many property owners and diminishes the free enjoyment of their property. They state it is the intent of RCW 496227 to allow property owners to remove all remnants of discrimination from their deeds. After making such a statement, the legislature clearly felt that eliminating these covenants from their deeds was insufficient and altered their original position to include the public record and chain of title in the final statutes.
And I'm aware of that, but I first thought it said remove all remnants from the public record, but it simply says remnants from the deed, correct?
Correct, Your Honor, in that legislative intent. However, once they altered it to the statute itself, it then becomes strike and eliminate from the public record. So clearly they felt just from the deed wasn't enough. And if there's one more thing I could speak on,
Mr.
county
Fry,
auditor.
Mr. Fry, one other question.
Yes, Your Honor.
If this is an in rem action, do all of the property owners need to be added to the lawsuit, which would include Mr. May's wife, who's not a party?
No, Your Honor, I think it's sufficient to have a property owner. It doesn't say the entirety of property owners, but the property owner enjoined in the action. And I would extend that to the entirety of the, I believe, 55 other parcels that have this covenant applied to.
Mr. Frey, I do have one question. I know you're over your time, but the question I asked Mr. Catt earlier is whether he was aware of any other statutory authority that authorizes a auditor to physically change a document that's been recorded. I'm unaware of any, but you acted somewhat excited about that as if you were aware of something. I want to know what your answer is to that.
I apologize for being so telling with my face, but I do have the auditor's duties that I could point to in that RCW 3622.010 defines that her duties in subsection 10 or subsection 6, I'm sorry, include to perform all other duties required by any rule or order of the legislative authority, including RCW 496227.
But you're unaware of any statute that authorizes specifically the auditor to alter a document that's been recorded.
RCW 496227, I believe, gives her exactly that authority.
Okay, but that's what we're debating.
Right. There are no other statutory authorities I could point to, Your Honor.
Okay.
Thank you. You are over your time, Mr. Fry, but I appreciate very much your arguments. Both the briefing and the arguments have been very helpful. Mr. Fry, congratulations on your oral argument. It was well presented and you are a testament to your school. So good job, Mr. Pham. We will take a short break before our next hearing, and this hearing is adjourned.
Following these arguments, the majority of the court agreed there was no need to physically alter existing records. The judgment on appeal is affirmed, but it was not unanimous. Judge Fearing disagreed, stating, "The time has come to rip from the pages of official records white inscriptions of supremacy. The time has come to tear down monuments to slavery and racial segregation on display in this public square." There you have it, folks. Do you agree with Judge Fearing? Let me know what you think in the comments below.